Hello, everyone, and welcome to NLTI. I hope all of you are doing good, all of you are doing well. And today we are going to continue our live YouTube live series where we are going to discuss important topics for your legal reasoning section. Now, in the last session where we met, we discussed about important topics among constitutional law. Today, we are going to discuss about criminal law, another one very important and significant component of CLAT legal reasoning section. A lot of weightage is there, a lot of questions are directly from the criminal law section. And like I've already mentioned, see, most of the times, um, there is not going to be direct question about a specific provision, right? What really happens in CLAT legal reasoning section that there are passages, and in every passage there are some legal principles that have been discussed or described, and based on what all has been given in the passage you have to apply those legal principles, and you have to basically solve the questions that are associated with that passage or comprehension. Now that is something which is applicable to this today's webinar as well, and which is also applicable to the criminal law section. Sometimes you will find that there are passages around criminal law and the questions are associated with the same. So again, if you do not have any prior knowledge about the law, that's absolutely fine. But just in case if you're familiar with those laws, it's going to help you save a lot of time in reading the passage. Also, you will understand the principle in absolutely no time. Automatically, you will be able to give more time to solving questions. You will be able to give more time to understand or interpret the question and analyze the questions and apply the principle carefully. So now that is something which we will be taking into consideration today, and we will be discussing what all different laws, what all different provisions you should be aware about under the criminal law. So now let's get started with the same. So first things first, it's not going to be too complex. The CLAT is not going to test how well do you understand the procedure of a criminal case, right? It's not going to test you if you understand what are different offenses under IPC, which section it is about, what is CRPC, what is BNSS, or what is Evidence Act. No, it's not going to be that complex. It is going to test how well do you basically understand the fundamentals of criminal law, right? So now that is something which is really, really important. Now, first things first, the basic and the foundation of criminal law are the general principles of criminal law, right? So every criminal case, it depends on the foundation of a core doctrine. Few doctrines that are always that are mandatory for every criminal case, right? So first things first, the two most important doctrines, which are the two pillars of every criminal case, is actus reus and mens rea. Two very, very, very important doctrines, right? So now any criminal case or criminal law, it is very simple, it is very basic. It says something really simple. It says that if you have done something wrong which is otherwise illegal, something which has been prohibited by law, and you had the intention to do so as well, right? You had the action plus the intention, only then a crime will be committed. If you only had the intention but have not committed any crime, or if you have committed a crime but did not had any intention to do so, it is no crime at all. So actus reus, which basically means the action, the act, right? Any criminal act that is mandatory for you to do. Secondly, mens rea, it means the guilty mind, the intention. So together, intention plus action will make a crime. Otherwise, it's no crime, there is no criminal liability if you have done something which where either one of them are missing. So what does that mean? It is really simple. Now let's say any criminal, let's say you want to hurt someone, you have an intention to maybe slap someone or maybe kill someone, but you do not do anything about it. It's just in your head. Okay, it's just an intention. It's just a thought that you have, but you haven't done anything in response to that thought. Then can you be sued? Can you be charged for murder? No. But let's say now you have accidentally done some harm to someone, but you were not having any intention. It was purely an accident. In that case, also, you're not liable. So, if you had an intention to do some harm to someone, and in pursuance of the same, you finally commit an act which through which you actually end up doing some harm. Okay. both these components will together make a crime, will actually make a criminal liability. Only then you will be liable. This is the basic fundamental of criminal law, and that is something which you definitely should understand, right? Then a few more important doctrines that are around criminal law is transferred malice. Now let's say you wanted to cause some harm to person A, and in pursuance of the same you did some activity, you did some action, and that action did not hurt person A but accidentally hurted person B. So in that case, will you be, does that mean that there is not going to be any criminal liability? No, you will still be liable. Why? Because there is a transferred malice. Malice basically means bad intention, right? So if you have a bad intention to harm person A, but due to your action, person A does not, is unaffected, but person B gets, is harmed, then also you will be responsible. Why? Because there is a malice, there is a bad intention. You couldn't execute your intention properly, that's separate, but still you had an intention, and that's something which basically means that is something really important, right? So if you have an intention here and to harm someone, but you end up harming someone else, that is called transferred malice. Then there is called strict liability. Strict liability is that principle you must have learnt about the same in you must have learned about the same in law of torts also, right? Strict liability says that it doesn't matter if you have the intention or not, you are still going to be responsible for the same. Now let's say you have a servant, right? Your servant is acting on your behalf and he commits some crime, right? So in that case, automatically you will also be responsible, and you will be responsible for any damage that has been done, any harm that has been done. The criminal liability will also arise, right? So in that case, the principle of strict liability is applicable. Then we have constructive liability. Constructive liability is where there is, you, it is again not about your intention here, it does not directly matters, right? Just like strict liability, just give me 1 second. Okay, I can see. Okay. Okay, so what we were discussing, yeah, we were discussing about constructive liability. Constructive liability is when something has been done together, right? Doesn't matter if you have that intention or not. Now let's say you and two of your other friends, you wanted to probably commit a theft in someone's house. So you go to their house, and one of your friends, apart from just committing theft, they also accidentally murders the other person. So now murder is also done. So now not just you will be just responsible for theft for which you had an intention, but you will also be responsible for murder even when you were not having that intention to do so. Why? Because if one offense has led to another offense, so you will be responsible for both the offenses, and that's something which the principle of constructive liability it provides. All right. And third thing which is very important is concurrence, which means that both actus reus and mens rea should exist in the same time. So you should be having a guilty intention, and you should also be committing any act in pursuance of the same, so that the criminal liability is there, right? Okay, so these are the basic principles. Now, okay, I think I've already explained the same. Now, let us understand a little bit more about mens rea. Okay, action is something really simple. If you wanted to steal something and you commit a theft, right, that is an action. But mens rea, it comes in different flavors. First, of course, is the intention. Intention is when you know what is going to be the specific outcome, specific result of your action. So if you have a gun and you know that if you will pull the trigger, then the other person will be shot and he might be killed, right? He might get hurt. So in that case, this is an intention where you know that okay, and you are doing this with an intention, with a motive to actually hurt that person. You have pulled the trigger so that you can actually kill the person. That's what intention means. Second is knowledge. Knowledge basically means that you know that if you are not, if you're fully aware of what can actually happen in this case, right? You know it for a fact that pulling a trigger can kill someone. So even if you were not willing to kill some other person, but you, it's just it's just common sense that if you pull the trigger and if there is a bullet in the gun, the other person might get shot. So if even if you were not having an exclusive intention, but just the knowledge that if you aim the gun to someone, at someone, and you pull the trigger, then automatically the gun will, I mean, the bullet will be shot, right? So that in that case, you have the knowledge of the damage that can actually happen to the person, right? And third is negligence. Negligence is where you were not having an intention or knowledge, but you were just careless, right? So in carelessness, mostly we do not have the intention to do anything wrong, but you still end up hurting someone. For example, rash driving. You're driving rashly. You know that there is a possibility, if you'll drive rashly, there's always a possibility that you might end up hurting someone. But you still knowing that keeps on driving rashly. That's negligence, right? So these are the different flavors in which actus reus and mens rea they come in, especially mens rea. Okay. So if you have a guilty act but you do not have any guilty intention, it is not a crime. And same way, if you have a guilty intention but you have not done anything wrong, you have not committed any act, that is going to be just a, that is also not going to be a crime. Okay, it's just something which is in your head. Okay, now I think I've already explained this to you, what it really means: transferred malice, strict liability, and constructive liability. Moving ahead with something extremely important are the different stages of crime. Very, very important. See, now, whenever a crime is done, it is not as simple as it looks. If you say that, okay, this person, A person killed B, yeah, A killed B. Now, it might sound something really simple, but when we talk about criminal law, it says that crime, it comes in different stages. First is an intention. Now, if A wants to kill B, if A wants B dead, right? First thing is that he should have an intention to harm B or kill B. Okay. First stage will always be having an intention for the same. Second is preparation. So now he has made up his mind that, okay, I want to kill this person. Second thing he'll do is he'll start preparing for the same. Maybe, he might arrange for a gun. He might arrange for any weapons which can be helpful in killing B. That's going to be preparation. Third stage is attempt, where he finally shows up near B and points his gun to him, right? That is attempt. And fourth is commission. Commission is when he has actually shot and which where he has killed B. So these are four stages of a crime. So whenever a crime has to happen, there has to be these four stages, right? So every stage is important. Now sometimes what might happen, that you will have your passage is discussing about commission of a crime, right? So now you have to keep in mind that, okay, a crime cannot be done directly. It is always done in four stages, and you have to identify if those four stages have been met or not. And something really important in those four stages is, the first of all is the intention. If there is no intention and other three steps are being met, it doesn't matter, right? However, your preparation stage will also show if there is an intention or not, right? If someone is, maybe let's say, arranging for a gun, or someone is arranging for any weapon, it kind of shows that this person has an intention to harm the other person, right? This person has an intention to commit a crime. So these two stages will reflect the mind, the guilty mind of the person. And these two stages, attempt and commission, will reflect the guilty act of the person. And together, these four stages will make a crime to happen. All right. So a lot of times you can have a question, or you might have a lot of passages around, yeah, you might have passages around stages of a crime, right, where different stages have been discussed. And then you might have application based question, where you have to understand if the act has been done, but if the intention was there or not, right? If someone is preparing, someone is arranging for weapons, it shows that this person had an intention. So if you have such application based question, it will reflect that okay, there was an intention, and if there is an intention and then an act has been done, it is a crime that has happened. Okay, moving ahead. Inchoate offenses. All right, so now inchoate offenses basically means offenses which are not completely done. Okay, now what does that mean? So in which what happens, this fourth stage, commission, is missing. Now let's say I want to kill person A. So what do? I first of all I prepare everything, right? I make a planner. How am I going to kill this person? Okay, that's my intention. And then I arrange for a gun or some weapons, maybe that's the preparation stage. Then I go to that person, point gun at him, and I try to shoot him. He somehow dodges the bullet and he's saved. So no harm basically happened to him. So in that case, I've done the act. I have attempted to kill him, right? So although the commission could not happen, but all three other stages of the crime, they were there. They have happened. So that is called inchoate offense, where the commission of the crime could not take place due to any reason. But criminal law in India also punishes such inchoate offenses, which means if you have attempted or you have prepared, right? Even in that case, you are eligible to get punished for the same. Now let's understand how does that work. First things first, first crime is abetment. Abetment basically means where you instigate someone or you help someone, you're assisting someone to commit a crime, right? If I'm provoking you that, oh, you know what, this person said that about you, right? And that's so bad. Had I been at your place, मैं तो नहीं सुनती अपने लिए बिल्कुल भी ये, but उसने तेरे बारे में ऐसे बोला, अगर मैं तेरी जगह होती मैं तो उससे गोली मार देती, and I would have said such things. That is going to manipulate or brainwash the other person, and the other person might decide or might get provoked or might get agitated and probably will form a guilty intention of killing the other person. So in that case, what I have done, I have instigated the other person, I've triggered him some way, and that's called abetment, right? So now abetment is also punishable. So if you are abetting a crime, you are pushing someone else that okay, you should definitely do this because this is something really wrong. This is not, I mean, you should kill that person, you should commit a theft maybe, right? When you are instigating someone or you are helping them to do something mentally or in action, that is called abetment. And so in abetment, you are not the one who's actually committing the crime, you're just the one who is basically motivating the other person to commit the crime, right? So even if you're a great friend to all of your friends and one of your friends really wants to commit a crime, but you are just there instigating him and you're just there supporting him or motivating him that, oh, don't worry, yeah, just do it. Just do it. I'll take care of the rest. Okay. That's abetment. You cannot do it. If you'll do it, that's also a crime under IPC or BNS, and that is punishable as well. Then we have conspiracy. Conspiracy is where two or more people, they plan and they commit a crime together. Okay, so now let's say and my friend I and my friend A wants to kill, we want to kill person B. Okay, or let's say I, my friend A, and another friend of mine D. Okay, we want to kill person C. So now in that case, it's two or more people. So what do we do? What we have done together, we have planned the entire thing. And okay, I will go and will bring person D to this place, to this spot, and person C to this spot, and A will go and probably bring a gun. D is going to do something else to maybe distract C so that B can finally kill D. Okay, so basically, two or more people, they are planning things together and they are executing them together as well. Now, that is called conspiracy, right? When you are conspiring, when two or more people together, they're coming together and they are planning and executing a crime, that is called conspiracy. So, even if my job was just to bring person C, the person who is the victim, my job was just to bring him to a spot, right? and I'm not the one who has shot him. I'm not the one who has done anything wrong to him. But my job was just to bring him to that spot so that my friend can kill that person. So, in that case, although I have not done anything directly, but still I'm part of the plan. And that's called being a conspirator. So, I am also one of the conspirators in that case, and I will also be criminally liable. Okay. Then is attempt. See, now attempt is when you tried to commit a crime, you couldn't do it, that's separate, but still you had an intention to harm someone. That is also punishable. That's why crimes like attempt to murder, attempt to suicide, all of them are actually criminalized, right? That's why there is punishment for all of these. That's not something which is allowed, right? So if you have just attempted to kill someone, you couldn't do it. You couldn't kill that person, but you tried to shoot him down. He dodged your bullet, that's separate, but you even tried it. That is also which is punishable, right? Why? Because it shows that you had an intention and you have also prepared well for the same. You couldn't do it well because you couldn't execute it well. But still, to prevent it from happening again, you will be punished. And attempt is also something which is criminalized. Okay. Then comes some of the general exceptions. Now, what does it say? There are some situations where even if you've done something wrong, still you will not be criminally liable. You will not be liable, right? It will be considered that you have done no crime in certain situations. Now, what all these situations are? First of all, if it is a mistake, right? If you've done something by mistake, you did not want to do it, but you still end up doing it, that's again because there is lack of intention, that's going to be a mistake, and you will not be criminalized for the same. Second is second is private defense. If you have done something, right, just to protect yourself. Now let's say some a person has attacked on you, or maybe has attacked on someone else, or maybe has attacked on some of your property or someone else's property. Now, to save the same, protect yourself, or to protect the other person, or protect the property, maybe, you basically, to save yourself, you attack the other person or you cause some damage to him, which ends up by through which you end up committing a crime. A person attacked on you, to protect yourself, you attacked on him, right? You retaliated, and in that entire thing, he got killed. So in that case, you're not responsible for his death. That's not something where you have done a murder. That's something where you have done a where you have used your right of private defense. So right, private defense is something which can save you if you were just trying to protect yourself. Then is consent. Consent is when the other person was aware that if this thing will be done to him, he might get killed by your hands, or he might be harmed. Okay. So now, if let's say it is basically when someone is, let's say you are a boxer and you are accepting to participate in a boxing match, right? And now accidentally you are your opponent hurts you this way that you get really really serious injuries. In that case, right, will you can you say that, okay, I have been hurted really badly and this person should be behind the bars? No, there will be no criminal liability. Why? Because boxing as a sport is really aggressive and it's violent as well, and there are chances of you being hurt, right? If you know that, okay, this is also applicable to cricket matches. Now a lot of times the bowlers, they bowl a bouncer, and let's say that bouncer hits the batter and it injures him. So can the batter say that, oh, this person has injured me with his ball, he should be behind the bars? No, because the batter knows that, okay, during a game there is a possibility that the ball might hit him and he might get hurt. So in that case, he has consented for that entire situation. So that person is not, the bowler basically is not liable for any crime, right? So that's going to be a defense. Next defense is insanity. Insanity here basically means any person um who is of unsound mind. Okay, we do not call them anything else. We say that when they are of unsound mind, which basically means if they're not um in a position to understand the repercussions of a situation, of any action, right? So that if that is there now, there is a person who's suffering from any mental illness and he commits a crime, that person can escape criminal liability, saying that okay, there is a defense of insanity that he has. Okay, then there is intoxication. Intoxication basically means if the person is under the influence of any drug, or if they are under the influence of alcohol. Now, but one very important thing about intoxication is that it should be voluntary. It should be involuntary. Sorry. If you are voluntarily intoxicated and then you commit a crime, let's say you and your friend, you went out, right? You went out for drinks and you have by your own choice have consumed alcohol, due to which now you're intoxicated, you are not in a position to understand good and bad, you're not in a position to decide what is right or what is wrong, and then you commit a crime, right? So in that case, you cannot ask for the defense under criminal law. Why? Because you have voluntarily consumed alcohol. But now, on the other hand, where let's say where you were not aware, or if you were forcefully intoxicated and then you were made to do some crime, then it is a defense. Intoxication in that case is a defense. Okay. Last is necessity. Necessity is a situation where you do something, okay, to basically you do a smaller harm to prevent a bigger harm. Okay, now um, let's say a person is driving on the road and he see that okay, there is a kid who's crossing the road. Now, to protect that kid from getting hurt, he bumps into a nearby motorcycle, and there was no person on the motorcycle, just the motorcycle was there. Now he has damaged that motorcycle, right? But that kid is saved. So to prevent a bigger harm, a smaller harm is done. Now the motorcycle owner, he might come to him and say, oh, you have caused so much damage to me, you've destroyed my property, all of that. Yeah, but he has done so to protect a kid, to prevent any damage that could happen to a kid, right? That is a damage that sorry that is a defense of necessity. So all these defenses are covered under your criminal law. Okay. Oh, I think I have already explained this to you. Okay, so now about mistake. Now, mistake as a fact is a defense that is available with you, but mistake of law is no excuse. So, criminal law says that okay, if you were mistaken by a fact that okay, this should be done, this should not be done, and any factual information, if you have mistaken, then that's allowed. But now, let's say you say that okay, I was not aware that this is a law. Let's say you are in India and you say you've been caught consuming drugs. You cannot say that I was not aware that oh, drug consumption is illegal in India. Ignorance of law is no defense. Okay, that's why see if let's say you're not aware of any traffic rules and you park in a place where parking is not allowed. And if you're fined for the same, you cannot say, oh, sir, I was not even aware that this is a no parking zone. Ignorance of law is no excuse. So, mistake of fact, yes, that's a defense, but mistake or ignorance of law is no defense at all. So, you will be criminally liable in that case. Private defense and consent, I have already explained to you. Insanity and intoxication, also, I've already explained to you. And yeah, like I've already mentioned here, we often find questions around voluntary and involuntary intoxication. What is going to be the effect, right? So if there is voluntary intoxication, you do not have any defense. However, if it's an involuntary intoxication, only then you can claim the defense. Okay, moving ahead. Okay, joint liability, very important. When two or more people, they are acting together to do one same offense, right? So in that case, both of them or all of them will be liable. Now, very common example we have is the example of riots. Right. So now whenever any sort of riots happen, there are a lot of people who come together and who vandalize public property, right? Who cause a lot of chaos in the entire society. So in that case, every person that is part of that riot is liable, and that's what joint liability says. Now this is something which, under joint liability, two very important concepts are: first is of common intention. This means that both of all the people should have the same intention. Now they have come together to cause a riot, to vandalize public property. That is their intention, right? So all of them have the same intention. Now let's say, um, there are people who want to commit robbery. There is a group of robbers who want to commit a robbery in a specific bank, maybe. Okay, they want to rob a bank. So now all of them, their intention is to break into the bank, take out all the money, scare people. They might even kill someone over there, right? Threaten them, take all the money and leave. That's what their intention is. All of them are on the same page mentally, right? That's their common intention. Second is common objective. Now, common objective is something which is different, right? It applies to something called an unlawful assembly, where five or more people, they come together to achieve one single goal, and it's a criminal goal that they want to achieve, right? That is common object. So now, in either situation, all of them, no matter how many people are there, if it's 3 people or there are 15 people, all of them will be jointly liable. Jointly liable basically means all of them will be responsible, all of them will be given equal punishment, right? It is not that, okay, one person has shot someone, one person has threatened someone. No, everybody will be responsible for every crime they have done under the same transaction. Okay, moving ahead. Mm, okay, I think this is I've already explained. Okay, we all out of time. We see questions around some specific offenses as well. First is the offense of murder, right? Murder basically means taking away someone's life, right? Homicide is killing someone, killing a human being. Okay. And what is important here, that murder requires an intention to cause death. Murder may you should have an intent to kill the other person, right? If you are willingly doing something which might end up taking away someone's life, and you know that doing this might take someone's life, that's murder. For example, if you're poisoning someone, you know it that if you're poisoning someone, they'll be dead soon. That is a murder. Similarly, we have something called a culpable homicide. Culpable homicide is also taking away someone's life, but culpable homicide is where you are taking away someone's life without an intention to kill them. Now, for example, let's say you get into a fight with someone, right? You get into a very heated argument with someone, and you get really enraged, and out of that rage and anger, you probably punch that person, and you punch that person with so much rigor, so much vigor, that that person got unconscious and he went into coma, and later he died. Now, here you were angry, but your intention was to hurt him, but not to kill him. But still, you have now somehow killed him, right? Now, that's culpable homicide, where you were not having the intention or knowledge, but also you have done it in any aggravated circumstances, where you probably got enraged, you got provoked, and you lost things in your head for some time, and you did something which ended up killing the other person, right? You did not want to kill him at the first place. It was out of rage or anger or any provocation that you ended up doing that, right? That's culpable homicide. See, both in murder and culpable homicide, the person is losing his life, okay? And both of them are crime. The punishment for murder is much more. Culpable homicide is also punishable, but the punishment is less. Okay. Now, then we have hurt or grievous hurt. Hurt is basically simple hurt, where you have basically caused some minor injuries to a person, right? Grievous hurt is where you have basically caused some serious injuries, maybe a fracture or maybe some displacement of any ligament, anything of that sort, serious injuries. Maybe you've caused a lot of damage, right? Loss of limb, loss of organ. That is going to be grievous hurt. So again, simple hurt is also punishable. The punishment is going to be less. Grievous hurt, since it's more grave, the damage done to the other person is more. Automatically, the punishment is also going to be more. Okay? All right. Then we have offenses against the property, which is also really, really important. First is theft. Theft means chori karna. When you take away someone's movable property, movable is really important. Movable ka matlab hai the property that can move, right? Maybe a car, a mobile phone, a laptop, things that you can actually pick and move. Pick भी important नहीं है, वो move कर सकते हो, ठीक है? That is when you take away someone's movable property without their consent, without their permission. That's called theft. All right. Then you have extortion. Extortion is where you basically um, threaten the other person, put them in a fear of losing their life or causing some damage to their family, and due to which you and then you ask for some property or some money in that in return. You might have seen it in a lot of Bollywood movies. All these gangsters, they call up these really famous rich people, and they'll be like, oh, if you will not give us 1 crore rupees, we might burn your house, or we'll kill you if you will not give us 50 lakh rupees, right? It's not kidnapping. They're not taking away any kid, right? They're not taking away anyone's um, then they're not taking away anyone out of their custody, right? But they are threatening them that, okay, if you will not do this, if you will not send us this much of money, you will be in loss, right? You will lose your life, or maybe your family's life, or maybe we'll burn your house, we'll burn your car, whatever it is. That's extortion. Okay. Then we have robbery. Now, theft or extortion committed with the use or threat of force at the time of offense. Now, robbery is now again, it is a sort of theft only, but it is done in theft. You're not using criminal force, you're not threatening someone. In robbery, you are taking away someone's movable property, but you're threatening them. Okay. Now, for example, a bank robbery. What really happens in a bank robbery? The robbers, they go to a bank, right? They put gun on the head of one person and they'll be like, give us the entire money, otherwise we'll shoot you, right? And that's robbery. You are putting that you are putting people in under threat of life. You're forcing them. You're compelling them to do something, otherwise they'll lose their life right there. Right? That's robbery. And then there is dacoity. Dacoity is where it's same as of robbery, but when it is done by 5 or more people together, it becomes a dacoity, right? A lot of times you might have heard that some dakus, they have gotten into some trains. So dakus are, they do dacoity, right? So these dakus, I do not know, I mean, what do we call them in English, but okay, in Hindi we call them a daku, right? So dakus, they get into a train, they threaten everyone that, okay, give us your jewelry, give us your mobile phone, give us all the money that you have, and it's always a group of people that is doing so, right? So now that's dacoity, when 5 or more people are doing that together. Okay. All right. Proceeding ahead, some special laws that you should know about. First is the POXO Act. POXO Act is protection of children from sexual offenses. So children below the age of 18 are protected from any sort of sexual offenses that can happen to them. Now these are gender neutral laws, right? It is inclusive of all the genders, and it is child friendly, and there are different codes for the same, and the punishments, they are really, really big under this law. Okay, it is just to prevent any sexual abuse, sexual harassment of children below the age of 18. Then we have UAPA, Unlawful Activities Prevention Act. Okay, now this is an act which is against terrorism. So if any person or any organization is found to be basically doing anything against the integrity or sovereignty of India, or is trying to cause some sort of terrorism in the country, then they are also punished, right? They are punished under the UAPA Act. This is the legislation for the for anti-terrorism laws, right? And again, the punishments are really high, and it's very, very difficult to get bail under the UAPA Act. Okay, sometimes get questions around the same. Okay, theories of punishment we can avoid. And then we have some other laws, which are the procedural laws. So now there are two types of laws, if you know about the same in criminal law. One is the substantive law, second is the procedural law. Substantive law tells you what is the crime. Okay, murder is a crime, then what will constitute a murder? If theft is a crime, then what will constitute a theft? That's what the substance, that is what the substance of criminal law is. That's what the substantive law tells you. Procedural law tells you that if a crime has now happened and if a criminal case has to be done, what procedure will be followed by the court to actually carry out that entire criminal case? That's something which your procedural law discusses. Now, the procedural law that we have is for criminal cases, we have BNSS, Bharatiya Nagrik Suraksha Sanhita. Earlier, we used to have CRPC, right? Criminal Code of Criminal Procedure. Now, very recently in 2023, we've had those new laws, BNSS, Bharatiya Nagrik Suraksha Sanhita. BNSS tells us what is going to be the entire procedure for a criminal case, right from how a complaint has to be filed, how an FIR has to be registered, how charges will be imposed on a person, what all different sections will be applicable if a certain crime has been done, right? What is going to be the procedure of the entire case, how the evidences have to be presented, how cross examination of the witnesses have to be done, how order has to be passed. All the rules around the same has been given in the CRPC, and the judges and the courts, they have to strictly adhere to BNSS, or earlier it was known as CRPC. And then we have Evidence Act. Evidence Act, which is now known as Bharatiya Sakshya Adhiniyam, right? Again, earlier the name was Evidence Act of 1872. The new criminal laws that we've had in 2023 have changed the name to Bharatiya Sakshya Adhiniyam, right? So now it is a law which tells about how evidence has to be presented in a specific case, and it is applicable on both civil laws and criminal laws. Okay, so if an evidence has to be presented, what sort of evidences are actually acceptable in the court? Whose responsibility, which party's responsibility it is going to be present a certain sort of evidence, right? And what happens if any confession or if any admission is done? What is going to be the criminal liability in the same? That is something in detail has been discussed in your Bharatiya Sakshya Adhiniyam, or which was earlier known as your Evidence Act, right? So a lot of times we get questions around Evidence Act where they just introduce what is Evidence Act, and then they'll ask you some questions based on the same, whether Evidence Act is going to be applicable on the same or not, right? So if you have a slight idea about what this law is, how this legislation functions, it's going to be easier for you to answer these questions. So now these were a few things that I had to share with you regarding criminal law, right? If you have any questions around the same, you can let me know. Otherwise, I'll wrap the session for now. All right, folks, thank you so much for joining. We'll meet again next Friday in continuance of the series on different laws under legal reasoning. We'll be discussing upon some fundamental basics of all the laws, right? So that's something which I had to share with you today. I'll meet you all again next Friday. Thank you so much, everyone. Bye. Have a great weekend ahead.